So over the weekend, we got some bangers of information out. And, Nick is trying to tell us he's got the key to everything. He's got the key to everything, chat. And he has, he's the man. He's the man with the plan. He says he's got evidence. It's a conspiracy. And I think it's very interesting. I think it's very, very interesting.
Just don't like to go your way, especially on drug cases, because of one very specific thing, like especially out here, right? Out here, there's one drug testing lab in the county. And the next closest drug testing lab is an hour away. And after that, it's another hour to the next one. So.
Okay. They're far apart. Very common in rural areas.
If they find a problem with the drug testing lab, every case then goes on the chopping block. So
true. That would be a very true thing if we found out that the local crime lab, and I'm assuming he's talking about the crime labs. So the Bureau of Criminal Apprehension, the organization in Minnesota who is testing Nick's drugs, he's claiming there's a conspiracy there. Let's see.
They're hesitant to find a problem with drug testing because then all of the drug testing that they're doing becomes suspect. And that means that, people who maybe have a drug case or whatever that makes sense.
You mean like when they find 26 grams of drugs in your house? That makes a lot of sense. Although, Nick, are you trying to claim that the crime lab isn't doing it right? I mean, that's a pretty serious accusation. Do you have proof they're not operating correctly? Has there been a scandal there? I mean, here in Ohio, we did have this issue. The Bureau of Criminal Investigation, one of their crime labs, and one of the regional crime labs, the guys were pencil whipping in that they did their certification training. So they were disciplined. A couple of them were fired. A couple of them were disciplined. And every time you had that person show up in a discovery, they didn't include their disciplinary record. Like, are you telling me something's happening, Nick? I mean, if you got the goods, son, let's share them. If there's government corruption, I want to be there with you. Let's get this corruption, son. Let's get that bread. Let's get this. I'm right there with you, buddy. Show me. Show me. Come on now.
Might be getting off. It might be able to use that problem. So in all the decisions about any drug testing lab are always like these limiting things like, oh, it's only this one. Like this is the only time it happens. Like, well, why do you have a bunch of decisions that go this way? But it makes it kind of difficult to fight and defend when the judge isn't going to go, he's not going to rule for you against the drug lab. Just not.
But what do you have to show he should rule against the drug lab? I mean, Nick, you can't just go into court and go, well, that's not true. That's not how it works. Come on, buddy. What's your proof there's a problem? Show it. Share it with the class. Leak it to the press. I mean, are you going to sit there and just cuck your way through this and like, well, I had the key to topple the whole system, but it didn't go my way, so fuck everybody. Like, that's really the plan here? If you got the keys, you got the goods to open the kingdom, tear down the kingdom. I want to see it. Let justice be done or may the heavens fall, Nick. Like, really, be about this. Let's go. I want it. Show me it. Don't talk about it, be about it. Show me the proof the crime lab's bad, and I got your back. Where is it? Where is it?
Maybe in a major metro area on certain cases, but out in the country when it's the only lab, no way. Not in a way that'll make the lab look at all bad. They're just not. They have no reason to believe you.
If you offer evidence, we would. You just can't go, well, Your Honor, it's bullshit. That's because they're not going to believe you. You have to show evidence. Where's your proof?
Because they think you're a drug user.
You are, and you're paranoid, and you're desperate, so you're going to say everybody's in on it. You need proof. You need proof. But anyways, he's got the proof, Chad. It'll be somewhere out there. It'll be somewhere out there.
System. I can't wait to tell you about the my case, though. I mean, win or lose, it doesn't matter. The stuff that's happened is stuff that should really trouble people about the system, and I have all the evidence to back it up. Like, it's not making it up. I've got recordings, I've got the documents, I've got all this stuff.
Like what real defense attorneys, when there's problems with discovery, problems with the investigation, problems with testing, you know what they do? That shit has been brought up and notified to the world that we know there's bullshit going on in Delphi, Indiana. What's he saying? Well, I've got some proof, and it's win or lose, it doesn't matter. Then show us, dude. This all sounds like bullshit. I mean, it is. We know he doesn't have it, because if he had it, he would have fucking done something with it already. Or there would have been emotion. Like, let's be real, chat. Like, I know that. But I'm just saying, like, this bullshit cope of, well, if I had it, oh my God, I'll tell you the real story. Okay. It's just, come on now. This is just sad. This is just sad.
Not to talk too much about it, but I mean, one thing people make fun of is that the government says that they gave me my video and that I downloaded it on July, whatever. They didn't present evidence that they did that. The judge just accepted that they did that, but they never did. They have not ever given me a copy.
They literally, and this is the problem with Nick here. The way Nick's theory goes, chat, is if you went to a movie theater and watched a movie, you went to watch Deadpool and Wolverine. You didn't actually watch Deadpool and Wolverine. You know why? Because you watched a copy of Deadpool and Wolverine. You didn't watch the original. The real Deadpool and Wolverine is sitting in a vault somewhere in Warner Brothers Studios. Or wherever the hell it's at. So you've only watched a copy of it. That's literally what he's trying to hang his hat on. This moronic, semantic word game nonsense that nobody has gone with. Nobody believes you, Nick. We talked about this in your Frank's motion. It's horrible. It's retarded. It's a bunch of fail. And like everybody laughing at you and telling you you're wrong. The Court of Appeal is going to say you're wrong. Supreme Court of Minnesota is going to be like, you're wrong, dude. And you're going to be like, they just don't get it.
Video, and they haven't gotten it from Rumble or YouTube. I can tell because I have the analytics, right? I can tell when the views stopped coming in, what day it was. Guess what? Views stopped coming in on the 21st because that's when I locked both of them down. There are no views on the 22nd. So that officer who said he watched my video absolutely did not.
Yes, he did, Nick. He watched your stream. Your stream was downloaded by COG, and then COG re-uploaded it. He watched your stream. Okay? To anybody looking at that, they understood what Detective Pomplin meant. I get it if chaps your ass that you fucked up, but you fucked up. You did some retarded shit. You filmed yourself committing a fucking crime. I don't know what more you want out of us, buddy. And like I said, guys, when we read the Frank's motion, I can't fucking believe that somebody made this argument with a straight fucking face. I really can't. I could see Nick doing, like I said, either he's just fucking coked and juiced out of his mind from all the liquor that he just can't think straight anymore. But his attorney to do this, it's like, I don't know, chat. I don't know.
He didn't. He has lied. But the state said, well, we gave Nick his video.
Mm-hmm.
And the judge said, oh, okay. And that's the reality of court. They didn't have to prove it. In fact, the judge came after us for not filing something to prove them out. The thing that my lawyer didn't file is...
Now here's the thing, Nick. This is where I'm really confused. I get that you're claiming your lawyer didn't do something, but if your lawyer fucked up, why don't you have a new lawyer, buddy? If your lawyer fucked this up, why are you still rolling with the Like, what? Did you want him to file Your Honor, did you want him to file a defendant's motion of nuh-uh? Like, whatever it is you think he should have filed, Nick, if he didn't file it, why are you still fucking paying this guy? Why are you still fucking paying him? Beats the fuck out of me. Beats the fuck out of me, dude.
It's actually great. That thing it's supplemental report 8. Okay. Supplemental report 8 includes 4 videos that the state sent me, actually Detective Pomplin.
Detective Pomplin.
Videos that he says that he used
Detective Pomplin
to make the warrant request, right? Mind you, the warrant was signed by the judge at 4:06 p.m. on the 22nd. Okay, that's important. 4 videos provided to me by the detective that the detective claims he reviewed to make the warrant request were all created after the warrant was approved by the judge. The lawyer tried to explain that to the judge, and he's just like, no, the state says it did this. But the state never provided any evidence that they gave it to me. They just said it. It's amazing.
That's interesting. And we're gonna focus on that real quick, chat. What is Nick's argument here with this bullshit of what's gone on? Well, according to Nick, and his argument is that these things were created after they happened. And that's clearly not the case. And we could show that multiple ways. And one of the ways we're going to show it is the motion for notice of appeal wasn't correctly done. We're gonna get to why this is an issue here for Nick. But first thing I want to talk about is the other things Nick mentioned here. So once again, this is Baldo the Great with some more legal musing here. This is so good.
My appeal. I hope guys, my appeal is going to lose, almost guaranteed, because appeals are for losers. Winning them is a long shot.
Yes, Nick is 100% right. His appeal is going to lose. And I'm glad he admits that. But we'll keep going. We'll keep going here.
Not making any bones about it. Believe me, I want my appeal to win, but it's probably going to lose. I haven't read it, though.
You should probably read, now notice, remember, guys, his attorney is already fucked up. His attorney's already fucked up. And he paid this attorney to write another thing for him, and he didn't read it. What the fuck? What the fuck, Nick? Come on, buddy. Come on. Oh, as Nick told Dick in that one episode, they're not sending their best, and apparently, Nick, you might send your best, buddy. Oh my God! And apparently, you're okay with it. I mean, maybe this is his thing. Like everybody just cucks him, and people just, his attorney just does shit work and takes his money. Nick's like, well, whatever. Oh, I can't speak up.
So I hope it's competent this time. That'd be good. Being a lot of criticism from people who should know better, insinuating or directly saying that it's me who's writing these briefs, me running legal defense and all that stuff in the strategy. You hire a lawyer to do that for you, and then you let him do it. It's infuriating. It's not what I would do.
Now, here's the thing, Nick. I guess, once again, you're reinforcing the notion. You're fucking paying for this. You're paying for this dog shit. That's real. So you had no hand in this. So, this gutter shit you call defense work, you're fucking, are you fucking paying for it? Are you getting your money back? Buddy, you should get your money back. Because this is fucking pathetic. I guarantee you kids down at the law clinic in your law school could probably have done a better job than this.
In some cases, and that goes both ways. It's not what I would do because it's very smart, angle to attack, or it's not what I would do because I don't think it's very useful. But that's...
You're the client. You can control how they do things to an extent, Nick. You are in charge. You're scratching the checks. You get to call the tune to a decent amount of things.
I mean, that's why you hire someone else. Again, I have so many stories that have to I'll have to wait until this is done.
So many stories, chat. There's stories. Oh, I'm sure, and I'm sure it involves Nick. You know, he walked into court and he shoved the judge into a locker. It's a case dismissed.
Everything's wrapped up. And like, specifically so, I have to really watch what I say.
You have to really watch what you say, but we're going to talk about some retarded shit here.
So I just won't say anything. Technically might not matter, but didn't you tweet that you did mountains of cocaine? I think I tweeted that I was on a mountain of cocaine at some point in time. Yeah, yes. It says absolutely nothing about the crime I am charged with. So I know some people are freaking out about it. Andrew was going on about that. Andrew's a fucking idiot. Like, it doesn't matter. Dude, if I otherwise am winning and they hang me on a tweet about doing mountains of cocaine at a completely different date and location, I guess they got me.
Now, here's the thing. When you look at this tweet, the tweet is talking about when somebody says, do you love your kid? Do your kids love life when they're dirty, smelly, hungry, begging for food and attention at school? Nick says, no, you never were. And you never did coke. And he said, I did a mountain of fucking cocaine. Now, Nick, this is where, and I'm going to put on my prosecutor hat for a moment. You didn't say when you did it. And you didn't talk about an indeterminate time and an indeterminate place. Okay. Well, Mr. Rekieta, you've been sober this whole time, right? Since the whole search warrant? Yeah, on the 23rd of you haven't done any coke since then, right? You've been testing clean for children's services. So all that happened prior to the 23rd. So now you're possessing cocaine at some time prior to the police showing up. And when the police showed up, you were possessing cocaine. Like, you're not helping yourself there. Could a jury reasonably infer you were talking about doing cocaine in the lead up to your arrest? And oh, look what we found. He was possessing cocaine in his house. Because use indicates possession. The crime is not that you used cocaine, Nick. It's that you possessed the cocaine. And guess what? When you're cramming it up your nasal cavity, you're possessing the fuck out of it. I mean, holy shit. Let's get on to what you're here for. You guys wanted to talk about a man grasping for a life raft in the middle of a fucking hurricane. Well, here you go. This is Nick filing a petition for discretionary review. This is also known as an interlocutory appeal. These happen from time to time. So, for example, a very famous one that we all just learned and known about is the one in Trump v. United States. There, former President Trump, appealed the presidential immunity issue all the way up from the D.C. District Court all the way to the United States Supreme Court. And remember, his case is not done. So Trump made a motion to claim presidential immunity. He got denied at the trial court level. He appealed to the Court of Appeals, and they said lol. And then it went up to the Supreme Court, and the Supreme Court went and said, actually, we agree with President Trump. There is presidential immunity. So this does happen. It's not very common. It's not the typical way you appeal. Normally you appeal at the end of your case when not only you've either been convicted and then sentenced, you then file an appeal, and then you get your matters. This is not an appeal of right. It's discretionary, meaning the court can deny it. Your appeal after your case is over is your appeal of right. Now, can Nick plea and still retain the right to an appeal? Yes, there are times where that does happen. It's not very common. It's pretty rare. And it requires you to do a lot of things right. And, the court and the prosecution would have to agree to it. And I'm sure that the prosecutor in this one's going to say, no, we're not going to let you appeal this. You're a fucking idiot. So this is Nick's only chance, really. So what's going to happen? He's asking the Minnesota Court of Appeals, please hear my case. Now, as he said, they're not going to, and generally they won't. And we're going to get to why they won't, because they even explain why. So when you guys are saying Francis White Law, PLLC, this is the Barnes Walker, Francis White. It's done by another attorney working for the firm, Brian Lewis. And then we have Kristen Pierce, the work representing the county attorneys. Now, this is the petition here, and it says, the defendant requests pursuant to criminal rule, the Court of Appeals to exercise its discretion, review the order of the district court, and request this honorable court. You guys always, and when you're writing to a court like that, when you're asking for something, you always address them as an honorable court. At the very least, you always capitalize court. You're trying to show them a little respect. You show them a little deference. And when you talk about the honorable court, you're kind of fluffing the balls a little bit. Courts like their balls getting fluffed. Grant this petition for discretionary review. Okay, so statement of facts to secure the search warrant at issue. Deputy Quinn Pomplin, oh yes, evil Mr. Pomplin, knowingly and willfully deceived and misled the signing judge through his application for a search warrant filed on May 22nd, 2024. Yeah, he did not. He did not. Detective Pomplin based his application on three distinct indices, none of which the defendant argued were truthful or sufficient to warrant a warrant to issue. A report received on May 16th alleging possible child neglect and controlled substance abuse. Well, remember, chat, we talked about this when you looked at the things. You literally can erase that part, and that's enough for the investigation already. Allegations of drug use. Already enough. The police can receive a report and investigate. As long as they're not securing a warrant, they can take data records. They can get information. Legal activity can sometimes be used at the police in looking into it. Your electric bill's really high and you're running a grow lab. There's all kinds of things they can do. Now, you may not agree with it, but them's the law right now. So, that's what it is. In his motion for a Franks hearing, once again, Franks v. Delaware, they alleged Pomplin failed to disclose to the judicial officer, the judge, the May 20th letter sent by Children's Services saying that the reports do not fit the definition of child abuse or neglect as defined under Minnesota's Children's Services and welfare laws. Now remember, the warrant has nothing to do with fucking Children's Services. It has nothing to do with neglect. And we'll bring this up again, chat, because I think, Nick needs, he doesn't get it through his skull. And I hope I hope at some point this does get through to him, because it's not working. And we're gonna have to talk about this, chat, because here it is. Here is Nick's case, guys. And once again, we're gonna do something fun. We're gonna redact. I'm gonna big old thick line like that. Big old black bars. Not bulls. But I'm sure Nick will salivate nonetheless. So we get down here. This is the search warrant affidavit, the application for the search warrant. It's got the affidavit in it. Let's get down here to the case background. Okay, so the police department received a report about possible child neglect and controlled substance use. Okay, we'll get rid of child neglect. We'll remove all the child neglect and maltreatment out of this warrant and see what happens. So we keep going here. The reporter indicated the 4 people from the church had gone to him reporting neglect to the children. Okay, so there we go. Reporting possible controlled substance use and a questionable relationship with an additional couple. I removed all the child neglect issues. Unlike reality, we can't do that. But there's nothing else here. We're removing all of it. We're removing all of it here. And look what the rest, it's literally 1, 2 words, 3, 4 words here, and a sentence. Probably less than 35, 40 words, Nick. That's what you're trying to argue here is critical. Because look at the rest of it. It's all about Nick's information. It's all about what's happening on social media. It's all about what happens on social media. It's all about what happens on social media. It's all about what happens on social media, Nick. I mean, we're going to zoom back out of this thing right here. I mean, Nick, here is the entire search warrant. Look at these parts you wanted to redact, buddy. I removed them for you. I gave you, look, that's all we got. A couple of black lines. That's it. And that just, once again, guys, just retouching on how pathetic this is. But let's get back to this one. Chat. So they point out this was 2 days prior to the application for a search warrant. Yep, okay. The defendant alleged the failure to inform the prior determination as material, as the initial predicate seeking a warrant had already been deemed insufficient by the very county agency charged with protecting children. Once again, we go back to this. right here. Guess what kind of warrant I could get? And if I was the prosecutor, you kidding me with this warrant? I would approve it. You have videotaped evidence of the guy on camera, literally the night before, doing drugs at his house. Like, okay, yeah, there's probably drugs in the house. Go file it with the court. I bet you'll get approved. I'd sign off on that because that's a warrant for cocaine possession. And I don't think there was any obligation there. It's context. It's a little coloring. It's background. And they talk about the video made by Aaron Imholt, which allegedly detailed drug use. I think you're going to lose here because you guys kind of like took a knee on this issue halfway through your Frank's motion. And he's a concerned citizen. And this is where Nick, and Aaron are jilted lovers. And that's the funny part. They don't explain what the problem is between them. I'm sure Nick, Nick, this is where you're going to have to come clean. If the Court of Appeals hears this, they're going to have to ask your attorney, what is the problem between Nick and Aaron? And your attorney's going to have to go, well, they were playing Naked Twister together and their dicks touched. You're going to have to bring this stuff up. So do you really want to go down this road, Nick? I don't think this is where you want to go, Chief. I don't think this is where you want to go. It's not going to end well. And then going through the threats and the complaints here, but it's ultimately this one. The video made by Nick and the white powdery substance was said to be present on his face. And during the motion for the hearing, Detective Pomplin materially misrepresented he was able to review the video taken off Nick's YouTube and Rumble Media sites. You're going to fucking lose here, buddy. Nick, we're trying to tell you. We're trying to tell you. We're trying to tell you. Once again, they're just fucking crying again. That's all this is fucking crying. Fucking crying. Now, this is the funny part here. For Detective Pomplin to have been able to review the original video on YouTube, he would have had to have served a warrant on Alphabet Incorporated, the parent company of YouTube. That warrant has not been produced in discovery and would be a potential Brady violation. Now, Nick is true there in that regard. If Detective Pomplin had served a warrant on Alphabet, Google, and YouTube to get that video, and that was never disclosed, that would be a potential Brady violation. But they didn't have to. At some point, could they? Maybe, sure. And once again, if, the prosecutor's out there listening, and this is just me wanting, if you want to be a big fucking dick to Nick, because he said as of last night, it sounds like he's still got everything on there. I mean, surely Nick would not delete evidence and tamper with an investigation. What I would say there is, you can always file like a subpoena for Nick's stuff. I think that would be fucking hilarious if you did it. But you could serve a search warrant on Nick because he's admitted to having the critical evidence. You could serve a subpoena on him for him to provide that video. I mean, there's ways you can do this. I mean, sure, you could file a warrant with like Google and all that, and file a search warrant all that way. There's other ways you can get it though, and that would be fucking hilarious if you did it. I'm just saying, if he wants to play fuck games, there's ways to play fuck games. So they go through this, they complain and complain and complain. So it's just a recitation of the facts and everything that happened here. It also, and notice they get back to the watermark. The watermark is not present in the original video. The watermark is open and notorious. In the lower right-hand corner, appears to mimic the branding of the edited video's host channel. So once again, I think, Nick, you want to copy strike everybody. If the videos have been materially altered, it sounds like you're already making admissions they have been materially altered. Why are you striking people from materially transforming videos? Unless you're arguing that's not a material transformation. So it's almost like anything you say can and will be used against you. I mean, just like, I know. You're like, I don't know what the fuck you think you are. Like, you think you're daddy big dick or whatever, but holy shit, buddy. You're making legal fucking statements. Apparently you don't believe this to be the case. The defendant filed a Frank's motion alleging the various material representations noted above. After argument and additional briefing, this court, the district court, the Honorable Stephen Wenzel, judge presiding, denied defendant's motion. Yes, he did. Denied. The court found that the information contained in the application was accurate and reliable for the viewing judge. There were no clear false statements, significant material omissions, or material misrepresentations that caused the search warrant to be false, misleading, or in violation of Nick's rights. Yes, and I agree. In regards to the video, the district court held it is unclear if Pomplin viewed the video from Nick's YouTube channel or from a third-party channel. Even if the video was a copy from a third-party posting, there's no suggestion the content itself was doctored, clipped, altered, or otherwise changed. Yeah, there's literally nothing to show that, Nick. The district court also noted using social media as a support for a warrant is somewhat unusual, and caution must be used to ensure an altered video is not used. That's correct. And then the court said, yes, from watching it, and remember, he had to watch all 4 hours of baldoing it up. There is no evidence the video is altered, a parody, or otherwise inaccurate, and that's true. Nick, this is where, do you have experts who can come in and say, look, Your Honor, it's compressed. The picture, the color quality is different. Compare and contrast with the originals. You've got nothing to present that. You haven't shown anything. This is where you got to do your fucking evidentiary work. You can't present the evidence because you don't fucking have it. You know, and specifically, they allege that Pomplin not only did watch the video, but could not have watched the alleged video that he did watch in which he produced a discovery had been altered. And it was a misrepresentation or reported otherwise to the signing officer. Yeah. So statements of the issue. Franks v. Delaware, yes. Did the district court err in not granting a hearing? And ultimately, that's what Nick's asking for, chat. He's not asking to throw out all the evidence. He's asking for the right to have a hearing. And you might think, well, what does that ultimately mean for Nick? Well, it means a little bit that if he gets his way, he gets to have his hearing, and he gets to put Detective Pomplin on the stand and go, ask Detective Pomplin, hey, is it true you like the Baldo? Why don't you like the Baldo, Detective Pomplin? What happened here? What happened there? What happened everywhere? That's what Nick really wants to do. He wants to have this hearing. And I think part of his plan is to get into that hearing, and they're going to try to trip him up and just make him sound kind of like an idiot. And I'll be fair, I've done that in suppression hearings before. You kind of take advantage of the cop and, or the parties involved, and you make them sound like fucking morons, and you run with it. You run with what you got, and you try to cause some damage. And sometimes it works. I will say sometimes it's worked beneficially well. Do I think Nick's going to get a point where Detective Pomplin sits there and cries and goes, you got me. I just fabricated all this evidence, Nick. Take me to jail. No. Now, what does this mean for Nick here? That's what he wants, and we'll get to what happens there. So the statement of review, why this interlocutory or otherwise non-appealable order is necessary. So interlocutory appeals generally are disfavored, and ordinary only final judgments are appealable. So if you guys ever hear or read an appeal, or you see like me or somebody else talking about appeal, you'll hear the term a final appealable order. Those are generally the only things you can appeal, a final order. An interim order is not generally something that can be appealed. But they say in the interest of justice, this court may grant a discretionary review of an order that is otherwise not appealable. In determining whether to grant it, the court considers a multitude of factors, which include, is the challenge ruling is vested in the district court's discretion? I would argue it's well within their discretion to make an evidentiary ruling. Whether the ruling is questionable or involves an unsettled area of law. No, Fourth Amendment law is pretty settled. Now, using a social media posting, is that new? Kind of not. I mean, it's no different than watching it live on TV, I would argue. If they were watching the 6 o'clock news and Nick is standing in the background just snorting rails off, a park bench, would that be enough? Sure. So I don't think that's really what they're, I know that's an argument Nick would make, but I don't think the court would see a distinction there. The impact of the ruling on the petitioning party's ability to proceed. Well, I mean, that is kind of a big deal for Nick if he doesn't get this hearing. Well, even if he gets a hearing, he's got to win it, and he's not going to win it. So this really doesn't affect it too much. He's still fucked. And that's really kind of the issue here. I mean, ultimately, because even if Nick gets this, Nick's really kind of his hose, because here's how this works. So Nick had his motion, and it got denied. And now Nick has an option. He's going to appeal it. Now, this appeal could do a couple different things. The appeal can say no, Well, if the appeal says no, Nick's toast. And otherwise, the appeal could say yes. And if it says yes, and here's where we are, chat. This is what Nick's looking at. We're going to do a little whiteboard time. We're going to do some Karl Rove here. You get that? The Karl Rove joke without the cocaine? So Nick can do a couple different things here. If the Court of Appeals says no, that's it for Nick. The Court of Appeals says yes, well, we go back down to the trial court level, and we have the hearing. And it comes back down to here, and we have the hearing. And Nick has two options from here, chat. Here's the two outcomes. Once again, if he has the hearing, which he might get, the court might grant him the hearing. The court might grant the hearing. I'm not lying. It might. Nick can have his hearing. And then what happens? The court could still say no. And why are they going to say no? Because Judge Wenzel's already seen all the fucking evidence. He doesn't think Pomplin lied. So having a hearing on it isn't going to change anything for Nick. So the idea of him granting it is pretty much non-fucking existent. So this is just like kind of what happened with Monty. He's spending all this time and fucking effort just to get fucking denied again in the best case scenario. So I don't understand why he's doing all this. You're still fucked. You're going to be in the same spot you're in no matter what happens. You know, the importance of the legal issue, it's not really that important. It's settled law. It's settled law here, chat. It's settled law. You know, whether appellate review would benefit from the development of a more complete record, or the ruling would be reviewable on appeal from final judgment. This is the idea that, look, we've barely gotten started on the issue. We need more evidence. We need more factual record to be developed. That's not really applicable here. Sometimes that becomes an issue. That's more of like, you see that a lot more in civil cases where you're dealing with summary judgment. They're like, we need more record. So number 5 really doesn't matter to Nick. And then number 6, the specific circumstances of the case. You know, these factors are not exclusive. They're not. And the court can consider additional factors and circumstances that may apply to the case. You know, these factors show review is appropriate at this point. Which ones? Which ones? You haven't said which ones you need. Now, they point out this case challenged is not wholly within the trial court's discretion. Yeah, I mean, it pretty much, you know, you're gonna be kind of stuck there at the end of the day. Because the court's gonna say, did the trial court abuse its discretion? And you know what they're gonna say? The trial court did nothing wrong. Therefore, the issue is what evidence is necessary to secure a hearing when the evidence is questions based on its modification is not within the trial court's discretion. You're not going to find an abuse of discretion there, guys. I mean, it's a review of what the trial court did. The trial court did not arbitrarily or capriciously. It didn't act in a way that's bad. I mean, it's got to be clear error. The ruling involves an unsettled area of law. It doesn't, though. It doesn't, though. Franks is settled law. Franks is from 1978. Franks is from 1978, chat. So as noted above, the defendant alleged Pomplin not only did not watch the May 21st video, but could not have watched it and alleged the video that he did watch, which had produced in discovery, had been altered. The question of what must be shown in the social media video context to demonstrate unreliability has never been answered directly in the context of a Franks motion. Okay. Well, you're saying it's unreliable. And this is where, once again, you have the original. Show us why it's unreliable. Here's the neat thing, chat. If Nick comes up, and he shows that video, his original video, and he shows that there's edits, he shows there's compression, he shows somebody fucked with the color and the sound and added in things and artifacts, you know what happens? The warrant probably gets fucking tossed. There's a reason why Nick hasn't done that. There's a reason why. And I'm sure the Court of Appeals is going to ask that question. The impact on the petitioning's party ability to proceed is heavily in favor of granting review. Given the findings of the fact, it's possible that questioning of Pomplin regards veracity and accuracy in the application for impeachment purposes would be disallowed. Maybe, maybe not, but that's where you got to start filing motions in limine and start filing things to figure out what you can do. This would have an impact on defendant's trial strategy. Whoa! Woo! Confirmation. I mean, I have other sources who have indicated me Nick is going to trial. But yes, we're going to trial, chat. We may be setting up a field outpost at Stoney's on the patio. Woo, lad, that'll be fun. Maybe Worski and PvP will come down. We'll do a unified command. The importance of the legal issue is significant and will only increase. The Minnesota Supreme Court has held that an appropriate ground for granting discretionary review is whether the question presented is troublesome or vexing. Is it really troublesome or vexing? It's been construed the question presented is both important and doubtful. Is it really important and doubtful? Is it doubtful that this was the right video? I don't think so. Determining whether or not a question is important depends on a weighing of probabilities. Importance increases with the probability that resolution of the question will have statewide impact on the probability of reversal. It increases with the length of proceedings terminated by the reversal, with the amount of harm inflicted on the parties by a wrong ruling of the court. Yeah, once again, chat, like I said, you know what the courts are going to say? It's no different than watching it on TV. Conversely, importance decreases with the probability of affirmance, the probability that trial will mute the issue. Question is doubtful only if there is no controlling precedent. That the question is one of first impression is not, however, itself sufficient to be deemed doubtful. And that's true. I bet there hasn't been, this probably is an issue of first impression, but just because it's a first impression doesn't mean it's novel. Nobody's been retarded enough to do fucking cocaine on a fucking live stream on YouTube. So guess what? This is a first impression. We haven't had this before, but there's a lot of ways we can apply law that makes sense. The question should be one which there's substantial ground for a difference of opinion. Yeah, there's not a whole lot of differing opinion here. And they used Westlaw, and that's a good legal search engine. There's no case law on point discussing what quantum of evidence is sufficient for showing social media video was sufficiently doctored to render a Frank's hearing necessary. You haven't shown the video is doctored, though. And I think this is a big thing the Court of Appeals, if they even hear this, is going to fuck you on, Nick. You're making a claim is bullshit. You have a burden of persuasion at that point to show the court why it's bullshit. You're going to have to show why it's not right. And just go and watermark. Well, when they watched the video, the watermark wasn't there. And it turns out it wasn't a watermark. It's an artifact from YouTube. We went over this at length in your Frank's response, buddy. The Court of Appeals is going to ask you, well, what did you fucking show? What did you fucking argue? Well, we cried about some fucking little squiggle mark on the side. Okay, well, counsel, is it true that your client still has the original copies? Yeah, did he provide those to the court for comparison? No. What do you expect them to do? They say, conversely, the seminal case on Frank's issues in the state only heightens the probability that review of this issue will be lost if not reviewed now. Would it really? Because if you went to trial, you can preserve your objection. This will be preserved on the record. Under that decision, the clearly erroneous standard controls our review of a district court findings to the issue of whether the affiant deliberately made statements that were false or in reckless disregard of the truth. And they say, well, the de novo standard controls our review of that determination, whether the alleged misrepresentations or omissions were material to the probable cause determination. In a decision after the trial has been concluded, if a conviction is obtained, the Court of Appeals may not be able to look. See, there's not even saying they can't. And this is going to hurt them too. You're not saying, yes, you can't look at this issue ever again. You're saying, well, you might not be allowed to. Well, you've got to speak very authoritatively to a Court of Appeals. Come on now. And the facts were found to determine whether the facts as presented constitute sufficient cause to issue the warrant. Where you're saying, well, maybe. That's not going to get you where you need to go. The Minnesota Supreme Court has also instructed a petition for discretionary review should not be granted unless reversal will obviate further proceedings. In this case, the criteria is easily met to the 90% certainty. It's so fucking cringe. Should the Court of Appeals determine that the defendant had raised sufficient allegations concerning the warrant, a hearing will be held pursuant to Frank's. Thus, a finding by the court will materially advance litigation and likely lead to further obviation of further proceedings on the merits. No, it won't. The judge who has your case already says you don't have enough. He's not going to change his mind all of a sudden. The trial court will deny your Franks ruling at the end of the hearing. Finally, public policy strongly suggests a petition for discretionary review be granted. Really? Does public policy support that? The policy of our state is to avoid piecemeal appeals that interrupt and delay litigation. That's exactly what this sounds like. It's interrupting and delaying litigation. Cite your objections and appeal at the end. In the instant case, discretionary review would neither delay nor interrupt the litigation, but would streamline litigation. Yes, taking like 3 months to fuck around on this would not delay the case. Somehow. That's are we sure that's ketamine logic right there, chat? That's ketamine logic. So the defendant articulates sufficient reasons for the court to exercise its extraordinary power of discretionary review. Has he articulated those reasons? No, I don't think so. The defendant's allegations of legal error should be remedied by this court to expedite the litigation. This is not going to expedite litigation. This court should also grant discretionary review because the Court of Appeals should use this case to provide guidance to the district courts on how to assess evidence gathered in the process to be used for determining whether a defendant has made a requisite showing of materiality regarding potentially compromised social media evidence. Once again, even if we have the hearing, you know what part of that's going to be, Nick? You know, this is your Joker moment. You're like, I'm like a dog that's got the car. I don't know what to do. When you do this, here's what the court's going to say. Here's what Judge Wenzel's going to say. Okay, so we have to have a hearing on determining whether or not this is done right. Okay. You guys have the video. Please give me the video. Nick, please give me your copy. Make it available for me. Guess what? That's the only way you can prove it's fake. So Judge Wenzel's going to have to watch you fake masturbate again and act like a retard again for another 4 hours and 4 minutes and 4 seconds. That's what's going to take. It's the only way to get around that. That's the only way to get around that. I mean, you're asking for the hearing, but how do you think you prove at the hearing that it's fake? You're going to have to use your video. Like, think, buddy. Come on. Respectfully, the court requests this review get granted. Signed by Brian Lewis with Francis White, part of the White Law Office. The White Law Office. And then we have this issue here. People were telling me, what does this mean? Did they grant it? This is from the Minnesota Court of Appeals. This is the case number that Nick will have on this. It has not been granted. Remember, the prosecutor gets a chance to respond. And they will. And then the court's going to go, denied again. I mean, really, what is Nick's best option at this point, man? You know, talk to the prosecutor, dude. See, like, is there, a way to reduce it? Reduce the penalty? Reduce the weight? Reduce the level of felony? Is there still some sort of intervention in lieu of conviction he can file? Some diversion, some deferred adjudication? Is there something out there still? Is it still in play, or has he been such a fucking asshole he's pissed that all away? Like, what can we get him? Can we get him probation? No jail time? Is there something we can do? I don't know what's going to happen for Nick. I don't know what's going to happen here, but I don't got a good feeling about it. I don't think it's going to work out the way Nick thinks it's going to go. I mean, he's going to get denied, and then what's he going to do? What's he going to do when it gets denied? Like, there's nothing to do at that point. You're going to be literally sitting there with your dick in your hand again and going, well, fuck, what do I do now? I don't see what you think you're going to get. He said there's a settlement hearing on the 25th, I think. Yeah, there is. In November, there's a settlement hearing. And that's going to be, what are we doing? That's going to, the plea settlements, we'd probably call it a plea deadline hearing here in a lot of the courts I deal with. Are we going to have a trial, or are we going to have a plea? It's shit or get out the pot time. Judge says, I'm done with the foreplay. Are we going to fuck or not? And I get the feeling Nick wants to go to trial. I mean, I guess he can't afford not to, or he feels like he can't afford not to. It's like, you're only making it worse. You're only going to make this worse as it goes. All right. So, guys, that's where we are. I'm sure the state's going to come in and say, lol, this is fucking retarded. And we'll cover that when it comes up. But it's going to be very quick. It's going to be very, very, very quick.